The Atheist Debates Patreon project presents the updated courtroom analogy. Years ago, Tracy Harris and I, one of my co-hosts on the Atheist Experience, were out at lunch and we were talking about new ways to try to teach people about the burden of proof. It's something that people still struggle with, even though we've come up with a number of different analogies, even though we've tried to make it as clear as possible. Probably the most confusing aspect, which I saw even today, somebody was responding to the gumball or marbles analogy and pointing out that, no, you really do have to make a decision if, either there is a God or there isn't a God, and you must choose right now, and it has to be one or the other. You can't possibly reject both. Well, it depends on kind of what you mean by reject, but you certainly can be unconvinced of both. And this is what we try to do with the courtroom analogy, but I'm going to have to update it today based on something that happened at a recent event. So first, kind of the old version. Essentially, when you walk into a courtroom, you know that the prosecution has the burden of proof. They have to convince the jury that you are in fact guilty. At no point do you have to demonstrate that you're innocent. If you can demonstrate that you're innocent, by all means, that's wonderful, because if we can demonstrate that you're innocent, then clearly you're not going to be convicted, or you shouldn't be convicted. But that's not required. If the prosecution fails to meet its standard of evidence such that it's convincing that you are in fact guilty, then the jury rules not guilty. The jury is basically saying, yes, we are convinced that the prosecution has made their case and this person is guilty, or no, we are not convinced the prosecution made their case and we're going to rule not guilty. That is not a declaration that the person is innocent. That is not in any way the fact that we're not convinced of the prosecution's case. Does it mean that we are convinced that the individual is innocent? As a matter of fact, you can actually sit on a jury, be personally convinced that the defendant is guilty, and yet if the prosecution did not meet the level of confidence that is required for you to render a verdict, then you have to vote not guilty anyway. You can suspect all day long that that person's guilty, but you've taken an oath to uphold the law, and if they haven't met their burden of proof, then your personal conviction needs to be set aside. This is how we were trying to describe the burden of proof. And there's some people who like the analogy and some who don't, and that's a separate issue. We've done it with gumballs and marbles, as I mentioned earlier. But I was at a debate with Blake Junta, and we ended up having a conversation a little bit about the supernatural and whether or not we should even count the supernatural among the list of potential explanations for something. And a guy came up to me after the debate, and he said that he felt that I was essentially not allowing supernatural evidence in the courtroom analogy, that I just was de facto saying, nope, we're not going to even consider this as a possibility. And that's not completely true. And I described this in a way that seemed useful to him, and I thought I'd go through that fairly quickly in a sort of updated courtroom analogy, and hopefully in a way that not only allows us to address the burden of proof, but to allows us to address what we are and aren't going to accept as potential explanations and why. So essentially, what you should do is put yourself in the position of the district attorney. Let's say we've found someone who's been mauled to death. They're out at the edge of the woods, they're mauled. And the investigators gather the evidence and come up with a potential hypothesis to explain how this person wound up dead. And they come to the district attorney and they present the evidence that they currently have. And the district attorney's job at that point is to evaluate the nature of the evidence, to consider the case and determine whether or not there's enough there that they think they can convince a jury. The district attorney might immediately think you've come up with the correct explanation, but they have to question whether or not you can demonstrate it. It's not so much that, I'm with you, the butler did it, or Bigfoot did it. In either of those cases, if the investigators come forward and put forth their hypothesis that Bigfoot did it, if they had enough evidence to convince the district attorney that in fact there was a Bigfoot, they had pictures and footprints and fur and other things like that, and this Bigfoot is the best candidate as far as what caused this individual to be mauled, then perhaps a district attorney could put it before a jury. Now, before you go panicking, yes, I realize that we may have difficulty actually capturing and prosecuting a Bigfoot, but this is about the nature of the evidence. If instead they came to the district attorney and they said, we're convinced the butler did it, then the district attorney is going to look at the evidence and say, yes, you have enough here that I can take this to a jury, or they can say, no, you don't have it yet. The district attorney may agree with you that the butler did it and just say you don't have enough evidence yet. Or it may be that the district attorney is also not convinced. I'm not convinced that you've got the right person, let alone whether or not you have the right of enough evidence. When it comes to the supernatural, and this is one of the reasons why I threw the Bigfoot in there, not because they're supernatural, but because it's an outlandish, unsubstantiated claim. If you want to put forward the supernatural as an explanation for something, when we have no way to investigate the supernatural, we have no way to confirm that it exists, we have no way that it can, in fact, be included as one of the potential causes of something, then it's my job to say, no, that doesn't get to be included yet. It's not an assertion that the supernatural isn't real and we don't ever get to appeal to it. It is an acknowledgement that, to this point, the supernatural can't reliably be considered an explanation for things. And when that changes, when you come up with evidence for it, when you come up with enough to convince us that a Bigfoot is here and responsible, or that this person was killed by ghosts, or whatever the potential explanation is, when there's enough evidence for that, then we will go ahead and proceed to trial. The district attorney is not in any way prohibiting the supernatural, and science doesn't do this either. Science doesn't say, well, we have come to the conclusion the supernatural isn't real, and therefore you don't get to appeal to the supernatural. There's a different reason, which I'll get to a little later, that science doesn't make appeals to the supernatural. Now, if the district attorney says no, that doesn't necessarily shut the door forever. You can go back and continue to investigate, gather more evidence, and further develop the foundation behind your hypothesis. And you can come back and say, hey, are we there yet? And at some point, you may get enough evidence where the district attorney can say, you know what? Now we get to go into the courtroom. Now we get to present everything we found to the jury, give them the instructions, let them see what we've got, and let them decide if we have met our burden of proof. Now, the analogy is going to fall apart when we're talking about an individual mind, because obviously my brain isn't a jury and can't be both the jury and the district attorney. That's fine. Analogies are never going to be perfect. But the point is, the courtroom analogy establishes where the burden of proof is. The district attorney portion of that analogy determines when we think we have sufficient evidence to warrant consideration by the jury. If somebody comes up to me and just says, hi, my name's Steve. Well, I don't have to spend much time on that. Whether Steve is the name that appears on their birth certificate or not is irrelevant to me. It might be the name that's on their driver's license. There may be no official capacity in which their name is Steve, but I'm willing to accept them at their word that their name is Steve, because at a minimum there's an implicit statement there that I would like for you to call me Steve. And I'm happy to call people pretty much whatever they want. I'll do my best to use whatever nicknames, surnames, pronouns, whatever, because this is about an interpersonal reaction. And there's no, if somebody came up and said, my official name on my birth certificate is Matt, the mere fact that they had to say it that way might actually give me pause as to whether or not how convinced I am of what they've said. But this process of we've observed something, a death, the existence of the universe, whatever it is, and now we begin to put forth a hypothesis that might explain that. Hey, he was mauled by a Bigfoot, he was stabbed by a ghost, he was killed by the butler, he was killed by, his wife. Then we investigate and come up with evidence for it. And if the quality and quantity of the evidence that we can present isn't good enough, then we don't have any business even taking it before the jury. Essentially, if what you're presenting me is not sufficient for consideration to reach a conclusion, then I'm not going to reach a conclusion. My position is going to remain, I am unconvinced, but you can come back to me with more. And so if you tell me that you are convinced that a God is real, or that ghosts are real, or that astrology works, or whatever, I'm willing to consider your case beginning in district attorney mode. Is there enough here? Are you presenting me enough information that I can pass it on to the jury portion of my mind, the portion that's going to make a decision about whether or not I believe or not? Now, obviously, this is not the direct process that we go through when we're presented with claims. It's not the case that I'm going to sit here and go, yes, now I'm in district attorney mode and I'm evaluating whether or not I want to pass this on to the jury mode of my brain. But it's roughly like that. If you are applying critical thinking, if you are behaving as a skeptic would, which is, I will consider your claim. I will consider your evidence that you would like to present for why you are convinced that a particular explanation is the best one. And then I will decide if you've reached the point where I should consider this with the purpose or the goal of reaching a conclusion. So if you come to me and you say, I'm convinced that God exists, and I say, okay, well, why are you convinced that God exists? And you say, because that's what I was raised to believe. Now, somebody out there probably just rolled their eyes back in their head so hard that it hurt, but this has literally come up on the TV show many, many times. When I've asked someone why they believe that a God exists, many times they've said, because that's what I was raised with. And I tend to follow it up by saying, do you think the fact that you were raised to believe something is a good reason to actually believe it? And there we get different answers. But I know that my answer is no. People are raised with all kinds of beliefs. People are raised with all kinds of claims that we later find out aren't true. So that in and of itself isn't sufficient. And you say, but wait, I have more. Great. I'm willing to consider more. And then you tell me the story of how you lost your car keys and you prayed and you found your car keys. And then I have to consider that evidence. And should that be compelling? Is it sufficient? And we may get to a point where you present me with enough evidence for me to think you've finally made a compelling case for the existence of your God, or for whatever explanation you're coming up with. That is the point where, in the analogy, as the district attorney, I pass it on to the jury portion of my brain, which is, hey, I really need to make a decision on this. And the decision is not, is God guilty of existing or innocent of existing? The decision is there enough here to actually convince me that a God exists? And if there's not, then I do what a jury does, which is I remain unconvinced. I vote God is not guilty of existing. But it's not like I dismiss the case, or if I do, I dismiss it without prejudice so that you can bring it again when you get additional information. The frustrating part of this was not only that people didn't necessarily understand the burden of proof, but that some people were making accusations of scientism, or you're not open to alternate epistemologies, or you're just saying that the supernatural can't exist and therefore we can't ever use it as an explanation. And none of those are in fact true. This was a debate with Blake, and the conversation was with somebody else out that wasn't Blake. But I think this is, as I've mentioned in a couple of videos, the sticking point. I'm not convinced that the supernatural is real. I'm not even convinced that there's been any sort of demonstration that it is probably or possibly real. So I don't get to include it among potential explanations for phenomenon yet. If at some point someone can convince me that the supernatural is real and is a potential candidate explanation for phenomena, then I get to include it. That's just the way it works. One of the reasons that science operates on methodological naturalism, which means we don't say in science, oh, the supernatural is not real. We say we don't get to appeal to the supernatural for this very reason. And there's another reason that is very important, and that is falsifiability. Essentially, falsifiability is the notion that for your model, your hypothesis, your theory to be considered valid and testable, it has to be falsifiable, which means that there needs to be some way, at least hypothetically, to demonstrate that your claim is false. And so if you were to say, there are no black swans, well, that is falsifiable because the second we demonstrate and find a black swan, we've demonstrated that your proposition has been falsified. It is potentially falsifiable. As a matter of fact, that's a prime example, and there are in fact black swans, and that's how it was falsifiable. If you appeal to the supernatural, and I'm going to use the word that annoys people who want to appeal to the supernatural, I'm going to use the word magic. Because supernatural and magical explanations, which I put into the exact same category, they're indistinguishable from my perspective now. As soon as you do that, every proposition becomes unfalsifiable. Everything. Everything that you thought was falsifiable before is now unfalsifiable because there's no way to demonstrate that your cause is the correct cause or is the best cause when there's a potential magical cause out there. And there's no way to ever prove that it wasn't magic. And we see this in conversations with believers when we talk about things like evolution. The scientific model of the theory of evolution by means of natural selection, which is a model that explains the fact of evolution. Evolution is just a fact, it's an observable fact. And then we have a model, a theory of evolution by means of natural selection that describes the process by which it works. Now, this is a falsifiable model that is supported by mountains of evidence. And you can go back to the finding fossil rabbits in the Precambrian as a means of pointing out how it's falsifiable. But for the people who don't want to accept that nature is sufficient, they posit that either evolution is false and some supreme being, some intelligent designer, some God manufactured life. Well, this is something you can't test, you can't investigate, and you can't falsify because there's no way to show that there wasn't a magic being manipulating. When you take a look at the change in allele frequency over time, you look at this as random mutations. Well, what if it's God? What if these aren't random mutations? What if there's a God and they're tampering with the DNA and stuff? These are the sorts of things people have claimed left and right. And as soon as you begin to propose these explanations for which there is no way to show that they are wrong, you have rendered that topic and any other topic where this might potentially be injected fundamentally unfalsifiable. Now, getting back to the courtroom analogy on this, if you could demonstrate that the supernatural was real and could serve as a cause, then all of a sudden it would be acceptable. If you go into courtrooms today, we no longer allow what's called spectral evidence. You don't get to run in and say, oh, Lucy Meyer turned me into a newt and I got better, or I saw her cavorting with demons and spirits. Because, first of all, we have no demonstration that that is real or is a candidate. There's no way to test it. There's no way to falsify it. It is worse than a sort of he said, she said scenario because we can never, as far as we can tell, get to the facts of the situation. We don't allow that anymore. At one point we did. But there are other things that used to not be allowed in courtrooms that we now allow, and things that also used to be allowed in courtrooms that we don't. For example, in the past week with the Kavanaugh hearings, we've heard quite a lot about lie detectors, or what's more properly listed as a polygraph. Now, polygraph tests, it's essentially, there are science elements to it. We're measuring galvanic skin response and other things, and heightened blood pressure and all sorts of things. And it's based on this notion that you are going to react certain ways to certain information. It's kind of predicated on the idea that if you think the lie detector works, you're going to be, much easier to read. But we've learned enough about polygraphs to realize that they are unreliable, that they essentially get into a sort of pseudoscience, that while there's some real science there, the foundational idea that I can hook you up to a machine and I can definitely tell that you are having a reaction to certain questions. But for me to conclude that that reaction is actually because you're lying rather than you're nervous about something else, or I've asked you a sensitive question. A lot of this comes down to the person giving the polygraph, how well they're trained, the types of questions, what the baseline questions are to establish all of this. And at the end of the day, polygraphs just aren't reliable and they're not admitted. There are other things that didn't used to be admitted, like DNA evidence. In order for DNA evidence to be admitted in a courtroom, we had to establish hard, reliable science. We did the same thing with regard to fingerprints. You couldn't just say, oh, well, we found fingerprints here and they matched somebody's, until we had developed a science, the forensic science that allows us to figure out which evidentiary criteria, which types of evidence are reliable. Is it the case that everybody has different fingerprints? What about identical twins? What about if somebody manipulates their fingerprints? Is there a way to fake this? There's no foolproof anything. Even confessions. We know confessions are coerced, and there are people who will confess, and it's not necessarily because they're seeking attention or anything. There are lots of reasons that someone might falsely confess to something. And so we have to, when we're viewing these things in a courtroom, consider, okay, DNA evidence is reliable, and we know what the reliability is. We know roughly what an error rate we're likely to have. We also know about fingerprints. And so when we let this evidence in, there's also jury instructions from experts to tell them, hey, here's the evidence, here's how we know it's reliable, here's why it's reliable, here's the extent to which it's reliable, here's how confident we are in it, and this should affect your confidence. And for example, you can never be more confident than the measure that you're using. If you have a measuring device, a tape measure that's accurate to within 1/8 of an inch, you can never be more confident about a measurement to more than 1/8 an inch clarity. Now, this is why supernatural evidence isn't considered in a courtroom. The frustrating thing is that some people want to consider it anyway, and they want to say, hey, we're not in a courtroom, we're not in a court of law. Well, you're right. We're not. We're not putting God actually on trial. We are not even putting supernatural causation on trial. But what we are doing is trying to reach a reasonable, informed decision. And I would think that in the same way that a courtroom has a number of different standards that apply, you can beyond a reasonable doubt, or to a reasonable certainty, or to a preponderance of the evidence as standards for different things, that this should apply outside of a courtroom. We're trying to do the best job we can to make sure that people aren't wrongly convicted. We have to do what we can to seek justice, and we want to impart this fairly, and we want to be reasonable. We don't want somebody to come in and just get railroaded because somebody claimed that a ghost came and told them that they stole the money. My grandmother appeared to me last night and told me you stole the money. Well, that just doesn't get to be admitted. And yet, curiously, outside of the courtroom, this is the sort of thing that people seemingly want to admit as evidence. In the debate that I did with Michael Kona, everything that we didn't have an explanation for seemingly gets put in the supernatural bucket. And if you were to walk into a courtroom and start talking about seeing ghosts or having trash can lids move, none of that, all that would be stricken from the record. It just doesn't, it's not even decent eyewitness testimony to what actually happened. Yes, we're not in a courtroom, but we should be. And we should probably be in something that is far more strict and stringent about what sort of evidence we permit when we're talking about the biggest questions out there. And by the way, the question of whether or not there's a God is an important question, particularly if one exists. And also, even if one doesn't exist, if there's a bunch of people who are convinced that a God exists. That makes it important. It impacts the world. And so we should consider that question. But if our standards of evidence are looser than a courtroom would allow, I think we've made a terrible mistake. We know people are wrongly convicted. We know that courtroom standards are not sufficient to get us anywhere near certainty. Not that we can be absolutely certain about anything, but we do the best we can, and no courtroom is perfect. No scientific test is perfect. No forensic scientist or model is perfect. No jury is going to be perfect. No district attorney is going to be perfect. And even under that flawed system, it represents about the best we can do for making decisions. Why is it that the issue of whether a God exists or whether the supernatural is real is not up to courtroom standards, and yet is sufficient to convince people all over the planet? Well, I can be convinced of something personally that would not hold up in court. It can be based on my personal experience. It can, be anecdotal. I can have just some interactions with some people that I can't prove to somebody else, but I've watched this person and I've seen the way they act, and I'm convinced that they're not, a particularly good person. That's all reasonable. but it's not necessarily reasonable for anybody else to be convinced based on my reason for being convinced. To get back to Hume, as I often do, revelation is necessarily first person, and to everybody else it's hearsay. And so while you might have had an experience that absolutely warrants justified belief on your part, that doesn't mean anybody else should be justified in believing you. And that's the last thing I want to kind of address. We've got the courtroom. The jury is analogous to me making up, am I convinced or am I not convinced? The district attorney is about deciding what's going to be presented to the jury and what's not, what's too prejudicial, what is fallacious, what is good evidence, what is not good evidence. And by the way, you can have awful district attorneys, and if you think that that's the case, if your thing is, Matt, as a skeptic, you're just terrible at this district attorney role. You've just got too strict, your limits on evidence are just too harsh. It's just unreasonable. If you keep this up, you could never possibly believe that. Well, that's not my fault. And if in fact there's a God, and he gave us a brain, and he allowed us to reason, and he allowed us to understand the nature of evidence, and to discover the processes by which we can make really good rational decisions, then it's curious that the evidence for his existence is excluded from the base level of a courtroom. We can't put God on trial, we can't present the evidence, that all of the things that people would want to claim as evidence for God, or not all, but a good chunk, what would wind up being sufficient, simply doesn't pass the courtroom test. It doesn't even pass the district attorney test. And this is not a district attorney saying, no, you will never get to bring forth supernatural claims. It is simply saying, until you demonstrate that supernatural claims are good, reliable, investigatable, potential causes, in the same way that DNA evidence and blood type evidence and fingerprint evidence, and we demonstrate that footage from a camera hasn't been tampered with, etc. Until you can get somewhere close to that standard, then we don't get to pass it to our internal jury. We don't get to make a decision based on it. And doing so would be far too prejudicial. It would be essentially poisoning the well, putting forward something to the jury, putting forward something to that portion of your brain that's going to decide whether or not something's believable based on flawed methodology. And when we do that, we wind up convicting the innocent and setting the guilty free. And it's not the individual's fault that if there's a God set up this situation to specifically, it seems, hide his very existence from the jury, from the district attorney, and I would argue, taking a step further back, from the investigators themselves. What direct evidence have we come up with? What is there to present to show that the supernatural is real? Nothing more than something happened that we can't explain, and so we're going to call it supernatural. Something happened and we don't know how, so we haven't been able to come up with a natural explanation, therefore a supernatural one must be the case. And this is obviously flawed. And for the people who want to think that skeptics are just ruling out God or ruling out the supernatural in an unfair sense, I think they've got a little bit more work to do to demonstrate why we should realistically consider their potential explanations. Because when somebody asks me, why is there a universe? Why is there something rather than nothing? How do you explain the origin of the universe? My answer is, I don't know. But you think you do know. And yet you don't seem to be able to present evidence for it. Now, that's not me being too strict about what sort of evidence I'll accept. There is a process by which we determine what are good evidentiary standards. And that process includes, is it likely to lead us to a wrong conclusion? Are we likely to accept a number of different potential hypotheses based on the same justifications? Could we say, if we allow God to be a potential explanation for the origin of the universe, wouldn't we also have to include universe-creating pixies or any number of other potential sufficient explanations, and not just explanations that are both necessary and sufficient, not just explanations that are the most likely proximate demonstrated potential cause of this, rather than a catch-all cornucopia? Because while God can serve as an answer to any question, it serves as an explanation for nothing, because it has no explanatory power. There's no way to demonstrate that this is, in fact, a candidate explanation, let alone the most probable or most likely one. So the courtroom analogy, burden of proof, the district attorney extension of that gets to the nature and quality of evidence that we evaluate. I'm sure we'll extend it out to the investigators and everything else beyond that. And at the end of the day, what we'll realize is that we've constructed an analogy that in total basically says this: I want to believe as many true things and as few false things as possible. I want to have a methodology in place that makes sure that I am more likely to be right than wrong. And I'm not under any obligation to make up my mind right now, this instant. But you could die tonight. Well, then I will die tonight, but I will die not having reached a conclusion without sufficient evidence to warrant it. And yes, I'm sure I've reached lots of conclusions without sufficient evidence. The goal is to try to do better than that. And if we can't do better than that when we're talking about lucky socks, I don't know how we can hope to do it on the issues that are far more important, which relate to gods and the supernatural and the afterlife. So no analogy is going to be perfect. This one gets refined. But the nice thing about this was that the individual who wanted to accuse me of scientism, wanted to accuse me of just de facto ruling that the supernatural isn't real, managed to understand it. And I hope other people do too. There'll probably be lots more analogies. There'll probably be lots more discussions. There's probably going to be lots more people who are confused about this. But we're going to keep moving forward to talk about the burden of proof, the nature of evidence, good evidentiary standards, because the goal is to try to be as correct as possible, to have our internal model of reality match the facts of reality as best we can. And we're going to get it wrong. And we have to proceed knowing that we are going to make mistakes and doing our best to make sure that we minimize those mistakes and the impact of those mistakes. And so I can't just accept that because you're convinced that the supernatural is the best explanation. That's not enough to convince me that it is plausible, possible, or even a potential candidate explanation. We'll see you next time. Bye-bye.
This video is made possible by supporters of the Atheist Debates Patreon project. You can find more information and add your support at patreon.com/atheistdebates.